Hello, everyone. This is Bernie Wolfsdorf. I am the managing partner of the Wolfsdorf Rosenthal immigration law firm. It is an absolute pleasure to speak with you all today about the exciting topic of adjustment of status. There has been a huge development, which is the reason for this webinar, not since August 2007 when we had VisaGate and the State Department opened all of the visa categories for adjustment filings have we had such good news. This is not quite as good, but fairly good. So without further ado, I do want to remind everybody that this does not constitute legal advice. If you want legal advice, please contact us. Our website, wolfsdorf.com, W-O-L-F, S for Sam, D for David, ORF.com, 1-800-VISA-LAW, and you can reach me via visalaw@Wolfsdorf, mylastname.com. And here we go, folks. A little bit about our firm. Wolfsdorf Rosenthal is a highly innovative and technology-focused immigration law firm. We developed a system called Rapid that has been described as jaw-dropping, next generation. This centralized cloud-based portal has made immigration processing so much easier for human resources and, of course, for the users. With our offices on the East and West Coasts, Los Angeles, New York, Oakland, San Francisco, Santa Monica, and our Shanghai office, our approximately 150 employees are here to serve you, and hopefully we'll be able to be of assistance. Briefly, our firm has been rated by Chambers, which is regarded as the top rating firm, peer review. We have band 1 rating. There's only one other firm in California with band 1 rating, that is in Northern California. So we are the only firm headquartered in Southern California with band 1 rating. Now, today we're going to cover several topics: the terminology for an adjustment of status. What does it mean to adjust status? Who is eligible to apply for adjustment of status? And then, of course, on to the October 2020 Visa Bulletin, which is the basis for this exciting webinar today. We do have to talk about the new forms, including the 944. This is a very difficult form that requires extensive support documentation, things like credit reports, and you need to start moving immediately on preparing the necessary supporting documentation. And then finally, the topic of filing fees, which is extremely confusing. 2 days ago, I would tell you we've got to file the new filing fees, but on the 29th, there was a preliminary injunction banning the new filing fees. So for now, we are using the old filing fees, the original filing fees, no change. So why is this happening? Well, something very good happened to employment visas. And this is because of unused family visas. Every year, 265,000 family visas are allocated to family immigration. And the unused family visas flow over to the employment category, giving employment a huge boost. And because of COVID and consular closings, large percentage of unused family visas are going to flow into the employment category. So this year, instead of getting 140,000 visas, we have almost a double quota of 261,500 visas, an all-time high, a record high, just shy. 280,000, of course, would be double, so just 18,500 shy of a double quota. What a fantastic opportunity for people applying for adjustment of status. My sympathy to the people waiting abroad for consular processing. They simply can't get appointments. Hopefully we'll see some improvement in the next few months, but it's been terrible, quite frankly. So, terminology and process. What is a permanent resident? A permanent resident or green card holder gives you the right to live and work in the United States for your entire life. And after 5 years, unless you got your green card through marriage to a citizen, 3 years, you can apply to become a citizen or dual citizen if your country permits it. So in a nutshell, the green card is the right to live in America, to pursue the American dream. And there's two ways to get it. One, file the 485 adjustment of status, and two, consular process abroad at a consul in your home country. So how do we apply for consular processing? Scratch that. How do we apply to adjust status, which is what we're talking about today? We require proper submission of the form I-485 with correct fee and supporting documentation. And here's the big one, folks. We can also file an I-131 and form I-765 employment authorization form, which will result in the issuance of the red combo card. Now, I absolutely love the combo card. The combo card looks like a green card, but it's not green, it's red. And it allows you to work for anyone and potentially to be able to travel and return to the United States. Make sure you have the correct combination. Now, there has been some delay in issuance of the combo card. In good times, it was 2 to 3 months. At the moment, it's 6 to 8 months, which is terrible. But it is nevertheless a wonderful thing when that red combo card comes in the mail and you realize that you're on your way to your green card. Now, as for the interview, many interviews are being waived. The policy was to interview all adjustment cases, but with COVID, we're seeing a lot of waivers. Hopefully that will continue, but we quite frankly don't know. Moving over to who is eligible for adjustment of status, it is necessary to have not an approved petition. It's nice to have an approved petition, but other than EB5, the 526, you can, with the I-130 and the I-140, file together. So you don't need an approved I-140. You don't need an approved I-130. What you do need is to have a visa available in your category. And if that is the case, and you're entitled to file an adjustment, you can file the I-130 and the I-140 together with your adjustment, resulting in the issuance of the red card. And hopefully when your number comes up under Chart A, final action date, you become eligible to adjust. Now for the I-526, which is the EB5 form, that actually has to be approved prior to being able to file for an adjustment. Now, focusing on the word available. Is a visa available? This is the magic word, because when a visa is available, you can move forward. I'm going to draw an analogy of a drawbridge. You want to cross over the bridge, but the bridge is up. Therefore, the visa is not available. Therefore, you cannot cross from non-immigrant visa to immigrant visa. When the bridge is open and the visa is available, you can drive from one side through to the other. So your priority date must be open under the Visa Bulletin. If you haven't seen the Visa Bulletin before, please Google search Visa Bulletin now, read it. It's complicated. And you need to look at the family chart. If it's family, you need to look at the employment. If it's employment, and you need to read the notes in order to understand this. So the big news for October is the Visa Bulletin for employment-based first, second, and third preference moved dramatically forward because of this double quota, because of COVID, because of unused family visas. Now, one of the other requirements is you must be able to cross that bridge and you must be admissible or eligible for a waiver of inadmissibility. 212 is generally the bad stuff. 212A, criminal inadmissibility. You have major criminal convictions, crimes involving moral turpitude, member of a communist party, other problems. You enjoy marijuana, great. That's legitimate maybe in your state, but not according to federal law. That is a class 1 crime to smoke marijuana. And if that comes up in an adjustment interview and use is established, you will be denied. There's medical inadmissibility, alcoholic, numerous different categories. The other big one we're seeing, unfortunately, is Communist Party membership. If you have filing for an adjustment within 5 years of termination of Communist Party membership, if your country is still under communist rule, such as China, so to be eligible, you must have quit the party more than 5 years ago or argue that it was involuntary and necessary to join and not meaningful. We're somewhat experts in this area, so we do handle a lot of these cases. Now, number one, we have to have a visa available. Number two, we have to have either an approved petition or be able to file a petition for which the priority date will be current under I-130, I-140. For EB5, you actually have to have an approved petition. And also for EB4, which is an I-360, you have to have an approved petition. But we won't get into those categories. You can also file for an adjustment, by the way, if you have an approved asylum case. 1 year after approval, you become eligible. But that's not subject to the quota in order to file. So, in order to file for an adjustment, you must prove that you were lawfully admitted or paroled into the United States. What's a lawful admission mean? Well, it means you didn't climb over the fence or under the fence. It means you came with a visa and you have an I-94 card. That shows that you were lawfully admitted or you were granted parole and paroled under Section 212D5. In order to adjust status, you also have to show that you have been maintaining status. That is, that you are in lawful non-immigrant status, such as on an H or an F student visa, and you do not have unauthorized employment. Now, Section 245I, which is hard to find, I mean, this is almost 19 years ago, will allow you to adjust even if you haven't maintained lawful status, but to qualify, you would have had to file for a green card before April 2001, 19 years ago. We're not seeing many of these cases anymore. Under 245K, which applies to employment categories, first, second, third, and fourth, they give you somewhat of a grace period, up to 180 days since last admission. So if you have less than 180 days of out of status, unauthorized employment, and you're applying to adjust under employment-based first, second, or third, you are eligible to adjust. If you have 182 days of unauthorized employment since last admission, your adjustment can and is likely to be denied. Now, let's talk about qualifying for derivatives. When you file for an adjustment, you can file for your spouse and minor children under the age of 21. Obviously, they need to be physically present in the United States in order to adjust an invalid status. If they were to come in on a tourist visa, we have issues of preconceived intent or visa fraud. Did they enter on a B with the plan to file for an adjustment? So that's complicated stuff. And then we have the big issue with the Child Status Protection Act. Now, the Child Status Protection Act does not give complete protection. It gives some protection to children. Basically, it allows you to file for your children and include your children under the age of 21, and you get to deduct the time the petition was pending. So if the I-140 petition was pending for a year, you get 1 year's credit on the child's age. But you have to take steps to freeze within 1 year of the approval of the petition. You must seek to acquire status, either by filing the DS-260 and paying the filing fee, or by filing an adjustment under Chart A. Today, we're talking about Chart B filings. These Chart B filings will not give Child Status Protection Act to your children. Now, I think this is wrong. It's a mistake. It's going to be litigated. I hope I'm litigating it because I think it's wrong. The regulations talk about, the statute talks about taking steps. Clearly, filing an adjustment is taking steps. And yet, USCIS is not recognizing, based on the State Department's determination, that only a Chart A filing will freeze the child's age. So be aware of that. This is complicated stuff, folks. Everybody thinks, oh, I can fill out a form I-485. Yeah, sure you can. But the consequences can be devastating for you and your family. So make sure it's done correctly. Make sure it's done by professionals who know what they're talking about. There's so many lawyers out there who claim to be lawyers, don't know any about this stuff. They don't even know as much as you know after listening to this webinar. This is complicated, and I'm only dealing with 1/10 of the issues that can come up in an adjustment. I'm just dealing with the basics here today. Okay, on to the big good news. This is the reason why we're all excited. This is an extract from the October 20 Visa Bulletin. This is Chart B, date for filing. And if you look on the left-hand side, for employment-based, 1, 2, 3, other worker, 4, 5, all current, everything is available and current for filing. In the Visa Bulletin, there is a link to the USCIS website which explains whether or not you can use Chart B to file. The good news is this month, October, you can. Will you be able to file in November? We don't know. In prior years, they opened up. Actually, there were 3 prior years they didn't open up at all. In this last year, they opened up and they stayed open for 4 or 5 months, if I remember correctly. That was unusual, unusually good. Let's hope they do the same, but we don't know whether they will be open in November, meaning that we may only have this 30-day window. Now, let's turn to China and India. Everyone knows that there are substantial numbers of backlogged Indian and Chinese nationals. Look at the first preference. Wow. So if you filed an EB1 and you're from China on August the 30th and it's pending, you are eligible to file an adjustment. Similarly, India. So even though you haven't been approved, you've got a pending I-140 under the first preference, you can now file a Chart B adjustment and get a red card, EAD, and travel card. Wonderful. The other thing that's important to note is that you can capture a priority date under third preference. You might later be able to upgrade that to second preference, and you might later be able to upgrade that to first preference if you have a second petition approved under any of these categories, EB1 or 2 or 3, you can carry that priority date with you from your previous employer. So a third preference priority date, if you have a third preference priority date that is not current, and you now file under the first preference, you can carry that old priority date from third to second to first, and the reverse is true. Now there's something very, let's turn our heads, weird, confusing. Because everybody's been trying to file under the second preference category, the higher category, many people have upgraded from third preference to second preference. So second preference now is much worse, particularly for India. India's second preference is in May 2011. Gosh, don't you wish you had a third preference? Well, yes, but file it anyway. So if you are from India and you have a 2014 second preference priority date, you need to downgrade and file a new third preference petition, and that will then automatically be current under EB3, and you can file your adjustment concurrently. So even though you're India May 2012, you're eligible. And similarly, if you're from China and you have a 2017 priority date and you're under second preference, you file an EB3 downgrade with your adjustment and carry your priority date from the prior petition. So this is fantastic news. Fantastic news. You don't need an approved petition under 1, 2, or 3 in order to file an adjustment and get the red combo card. Moreover, once your adjustment has been pending for 180 days, you can port. You can move to the same or similar employment or to self-employment in a similar category. So there is freedom for many in this visa bulletin and an ability to transfer employers. Good luck in this tough environment, but the reality is that once the adjustment's been pending more than 180 days, you do become a free agent, provided you port to the same or similar employment. So to give you some prediction of what's going on here, under employment first preference, we are current for the worldwide. China and India, we anticipate rapid movement in the next few months. Second preference, similar situation. Third preference, similar situation. Mexico, current. Wonderful. We haven't seen this for a long time. Employment third preference, current. China, steady forward movement. Fantastic. Employment fourth preference, also moving nicely. Now, finally, something that doesn't make sense to me. They didn't move the employment-based fifth preference for China. And I think the problem is that most people consular process in Guangzhou, and Guangzhou is pretty much closed, very much closed. So I think they should have moved the visa bulletin to allow people to adjust in the US. There's another issue or challenge, and that is the number of 526 petitions that were filed in 2015. We are talking thousands and thousands of Chinese visa petitions filed in 2015. So it's still going to take some time to clear out that backlog, but we're very disappointed with the slow movement in the Chinese visa numbers. Hopefully we'll see that pick up as the consulates reopen and Guangzhou starts issuing more EB5 visas to the Chinese nationals. So EB2 to EB3 downgrade. The EB3 is much better than the EB2, so we're going to have to downgrade. It does require some skill. There's questions about whether you file an amendment or whether you file a new petition. Your lawyer better know what they're doing. The good point here is that you can transfer priority dates from EB1, 2, and 3 backwards and forwards. EB1, so if you file an EB2 and you're from India You capture your priority date, and then you publish some more, become a full professor, file an EB1, and then you keep the old priority date. So priority date transfer between 1, 2, and 3 is doable. 3, 2, and 1 is doable. So once you've captured your priority date, you keep it forever. Even if the petition's withdrawn by the employer, you've got your priority date. You do need an approved labor certification for many of these petitions. And I'm talking mainly about EB2 and EB3. Yes, there's exemptions for national interest waiver. That, by the way, I don't know if you folks listened to our webinar yesterday from my partner, Cliff Rosenthal, such a smart fellow. He did self-petition options. That means when your employer doesn't want to sponsor you, what can you do? EB1, NIW, lottery. Those are pretty much your self-petition options. So anyway, what we do here is we need to file a new I-140, not an amended I-140, and we can concurrently file the 485. That is the beautiful word, concurrently, together. We file the I-140, we file the 485, and why are we so excited about this? Because we get the combo card, and because eventually we get the green card, but we are worried about our child aging out. If we have a derivative, a child abroad, we have to file an 824 following to join as well. Obviously, we do not revoke or withdraw the original I-140. These are the forms that we basically use. The 485 adjustment of status application, 131765, medical exam. Do you need to do your medical exam? People do it differently, even within our firm. Some of our lawyers like to, some of them don't. Potential for the medical exam to expire when you're filing a Chart B case is real. Follow the advice of your attorney, including our attorneys. I'm not going to give a blanket advice on this issue, and then you guys are going to get upset when it expires and you have to do it again. Finally, the 944. Yuck. Yuck, yuck, yuck. What does that mean? It's a tough form. You got to prove self-sufficiency. This relates to public charge. And by the way, there's new guidance on public charge coming out, which is going to put more burdens on potential sponsors. That's the 864. Applies mainly in family immigration. But obviously, that's a big issue. I don't like to read, but anybody who at any time is likely to become a public charge is inadmissible. I mentioned about problems like criminal convictions, Communist Party membership. We're seeing a lot of headaches there. So if you've got that, you need to talk to us about it. We're pretty good at addressing those issues. But this rule was finalized in October 2019, being subject to litigation. Here's the bottom line. The regs are like 50 pages. Anybody who receives one or more public benefits, and I'm not going to go into what is a public benefit because that's another 2-hour webinar. But if you've got a public benefit for more than 12 months in total, within any 36-month period, receipt of 2 benefits in 1 month counts as 2 months. You do the math. Did you receive a public benefit? We do have a problem on our hands. You can show totality of circumstances, but the public charge rule is real, it's serious, it's problematic, but not so much for today's audience. Why? Because we are mainly dealing with employment sponsorship today, and all of you folks have jobs. So people who have jobs are generally in good shape. If you got laid off from your job, well, to show it's temporary and it's more complicated. So USCIS will look at your age, your health, your family status, your financial status, your education and skills, and whether the 864 is sufficient. Now, this is the documentation you need for your 944. Folks, if you want to file this, get moving on it immediately. Most important, your credit report. You need to get your credit reports, health insurance. You've got a bankruptcy, proof of income and assets, education skills, employment history. The 944 is a monster. So what do we like? 250% of the FPG income. It's not that much. I looked at it yesterday. I think for a family of two, about 12,000. So you have 250%, takes you to about 50,000. Bottom line is it's fairly easy to comply. You have private health insurance. These are the positive things. So if you're 250% of the guidelines, income guidelines, poverty guidelines, then you're pretty much safe. And I suspect that most of you who are employed are over 250%. So I'm not going to like harp on this issue other than you better make sure you have the evidence. It's not whether or not you've got to complete this monster form because it's determined on a totality of circumstances. Now let's talk about confusion. What is our confusion today? Well, today is October 1. We can actually start filing today. We file by FedEx. I wouldn't file by mail. Who knows what's going to happen with the mail in the next month? So we're going to pretty much file everything via FedEx to the lockbox. And what fee do we put in? Well, 2 days ago, we were planning to put in the new fees, which I've listed. No longer applicable. 2 days ago, a federal judge has issued a preliminary injunction barring the new fees. They've been temporarily enjoined. But USCIS is going to appeal this. Eventually, they're going to get these new fees, in my opinion. So how do you know? Well, check our news bulletins, client alerts, and here below is the fee calculator. But remember, you may calculate, cut your fee, and then they change it the next day, in which case you're in a mess. So what's the solution? Well, we're not magicians, but we do our best to comply with this one, the fee calculator, and we watch for news that there's been a change. If the fee amount is wrong, at the time they receive it, you will be bounced. Maybe they'll sit on your file for a month or two, and you get it back 2 months from now. And you go into meltdown mode because you cut the wrong fee, or you put the wrong date, or you wrote the amount, what I call the British way, wrong way round. The date. That will mess up your check. Get it right, and don't bounce that check because your application will be rejected. So getting the fees right is absolutely critical. So that's pretty much what I wanted to cover today. I hope some of this has been helpful. Let's take a few questions. What is the cost for hiring you to do this work? I don't like discussing fees. I don't know your case. Email me, please. I always answer this, $10 million. No, we're reasonable. We're competitive. Email us. We'll quote a fee. We can find out what. If you're looking for the cheapest lawyer in town, we're probably not the cheapest. If you're looking for the best, well, I think our team's pretty good, but they're working round the clock right now. So we need to get everything perfectly. Can I file I-140 and 485 simultaneously? Yes, if your priority date is current. What is the lowest risk deadline to make for this filing? Well, we don't know. It may be open in October, maybe open in November, maybe open in December, but you have to assume that it may end October 30th, 29, because you've got to FedEx it in. You can't hand deliver it in. So we got a month. You got to focus on there being a month. My priority date is February 2000. Notice EB3 is current. Can we port from EB2 to 3? It's not porting. You have to file a new petition, as I explained. File a new petition. It's a downgrade. 212, adjusting status, and I-130, INA 212. Your question is not clear, Virginia. You need to email me separately. Next question. I have an approved I-140, previous employer EB2. January, I changed jobs. Can I now downgrade to EB3 and file without the perm? No, you got a problem. You got a problem because you don't have a perm for your current employer. The only option is to go back. So they'll take you. Oh, convictions. Oh, yucky, yucky poo. Look, with convictions, we have to see if they are convictions relating to moral turpitude. We have to see if you've got waivers. Can you freeze the child's age? Not under Chart B filing. Chart A filing, yes. By the way, for family second preference, that spouse or minor children of permanent resident, you actually use Chart A, which is better than Chart B. Is there any requirement of elapsed time from arrival in the US on employment before you can file? Very good question, Anonymous. I like your question a lot. Yes, there is. If you came on a tourist visa on Monday and you file an adjustment on Tuesday, you are almost certainly likely to be denied for preconceived intent, fraud, visa fraud. On Monday, you say, oh, I'm a tourist. I'm coming to see Mickey Mouse. On Tuesday, you file an adjustment of status. Well, wait a second. That means you lied on Monday. So what are the rules on this? Confusing as usual. The USCIS has a 60-day rule. The State Department has a 90-day rule. If you come on a tourist visa and change your intent within 60 to 90 days, so really it has to be more than 90 days, although USCIS says 60 days, so you want to be bold, but if you get hit with the 6C, it's a 99-year bar. 99 years. Good luck, Mr. 100-year-old, getting your green card. So visa fraud, does that apply on an F1? Not so much, maybe. J1, not so much, maybe. Sorry, there's no black and white answer. I can't answer everything. As for your H, no problem. You came back on an H, file your adjustment the next day. Came back on an L, file your adjustment the next day. What about a dual intent visa like an O1? Give it some time. Otherwise, you may have a risk. My PD is October 2011. Do you recommend to downgrade or wait for next month, hoping it will move to October 2000? No, I'd file a downgrade. We don't know what the movement is, but they are saying, but just to be safe, if you can file a downgrade, why not file a downgrade? There's going to be so many people filing. You want to get in this line, folks. I'm so sorry, but you have to join this line. Which line? This new adjustment of status, October 2020, is going to be remembered for a long time. People have been suffering. I don't need to tell you because You guys have been suffering. But there's hope for some of you. Can I use my EB2 priority date again if the date for final action progress further after I downgrade to G? Yes. If the adjustment's based on the EB3, you can ask them to move to the EB2. Some people say you should file a second adjustment. There's two ways to do it, but yes, if you downgrade, you can go back up in most cases. My wife and I are from Germany and green card holders living in the US. Our son is a German citizen as well, currently finishing up his bachelor's degree on F1. What is our best chance to get a green card for him? F2B, lottery. Yeah, look, you need to contact me. I need to look at it. Email me. He's on an F1. So he's over 21 apparently, because you're talking about F2B. F2A is current if he was under 21. Lottery, yes. But you seem to be focusing. If you can become US citizens, that will, first preference is not even better than second. Have to look at his case. Maybe he can stand on his own. Is the public benefit only federal benefits or state benefits also? My understanding is state can count against you. My son has ADHD and gets accommodation at school. Does it count for federal? I've got to look at these, each one individually, not going to give legal opinions here on these type of questions. How much processing time is expected for the EB3 downgrade? Well, you don't need to wait for it to be approved. Just file it together with your 485 if you're current. If you can premium process, fine, but you don't even need to. If we file a downgrade application now, November Visa goes forward for a few months, would make me current. Can we cancel the downgrade and stick to the EB2? Yes, yes. You can always withdraw and refile. So there's going to be a lot of that going on. Let me watch the time. We hit an hour already. I'll keep going. Answer, I don't know how many more questions I have. Maybe I have hundreds. I can only see them one at a time right now. Oh, 70 questions. All right, I'll keep going. I just give fast answers. Maybe I'll get through them. Maybe there'll be one I can't answer. Scenario with the same employer, perm, EB2, EB4 for location X, move to Y, closed X. Can we use X perm to do a downgrade? It's right on the border whether you can do that. You have to have good faith intent. Location does mess up the perm. Yikes. You're on the fence. I'm on the fence there. Very aggressive. At what point should dependents be added? Wow, what do you mean? At the same time. You always file for all your dependents at the same time. You don't want to leave out a kid. No child left behind. Oh. India, March to 10, downgrade recommended. You see, what's going to happen, folks, is everybody's going to downgrade. Third preference will then backlog. So if you can't file the 485 as well as downgrade, it may not be worth it. I promise you EB2 is going to catch up. Everybody upgrades, all the sheep run to one side of the boat, it tilts, then we run to the other side of the boat. So I'm on the fence. Maybe you should downgrade, but ultimately EB2 is going to catch up. It's only if you can benefit from this current opening. Is there any criteria that says individuals EB2 who are close to the date, say have more chance than people with PD late 2014? Not really. Well, yeah. I mean, your chart A is still going to become current earlier. Folks, we are at time. Looks like I could probably, my birth certificate is not in English. Where can I get my birth certificate translated? Anybody can translate it if they are competent. They complete a translation certificate. Doesn't even have to be notarized, but you need a translation certificate. There's companies that do this. It doesn't have to be done professionally, however. What is the downside to Downgrading, well, there may be some issues if it's not done correctly. Interfiling, part of the process. Yes, interfiling is something we do, but the problem is that sometimes those petitions don't match the file. Is there a similar jump expected? Not as much, but as we explained, forward movement anticipated. When is the birth certificate really required? Technically, it's really required at the time of filing. They could technically bounce it as deficient. You may get an RFE or you may not. Try and get it. Get all your documents ready. Credit report. Look, some people are not going to have them. Get whatever reports you possibly can. Some people are going to file with minimal 944 documents, wait for an RFE. I like to get everything if I can, but the truth is you're not going to be able to get all the documents. Folks, I could carry on and on and on, but this may be boring if you don't fully understand the question. So I am going to say thank you so much for joining me today. It's been a pleasure. I hope this has been informational for you. My email address is bernard@Wolfsdorf. Please put in the byline webinar question because I get a lot. We have a big staff. We have over 35 attorneys. We have over 150 people on our team. We've become one of the bigger firms in the nation, but we certainly have the best technology, pardon my bragging, but you'll see it when you use it. Thank you so much, everybody. I hope you enjoyed this webinar. I hope you enjoyed yesterday's webinar, and I look forward to the next one. This is Bernie Wolfsdorf from Wolfsdorf Rosenthal signing off today. We can be reached at 1-800-VISA-LAW. We can be reached at VISA-LAW@Wolfsdorf. Wolf like the animal, SDORF. Thank you so much, everybody. Until next time, goodbye.